bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good morning, Your Honor. This is Oliva Bretaña, Spanish interpreter. The interpreter has not been sworn.
Good morning.
Please raise your right hand. Do you swear to translate from Spanish to English, English to Spanish, truthfully in these matters here today?
Yes, I do, to the best of my abilities, Oliva Bretaña, Spanish interpreter.
All right, good morning, sir. Could you state your name, please?
Andre Eloy Díaz Rivera.
Andres Eloy Diaz Rivera.
I could try and speak English also. I can understand English.
Okay, because we have the interpreter, let's just use the interpreter. All right, Mr. Rivera, you're here for initial appearance in case number 22MM1072. You've been arrested for the offense of battery. It's domestic related. I'm going to appoint the office of the public defender to represent you. All right, does the state have a position on bond?
Your Honor, the state will request a $1,000 bond, no contact with the victim, no drugs, no alcohol, maintain separate residences, no return.
Does the defense have a position on bond?
Your Honor, he otherwise does qualify for pretrial release, so we would request pretrial.
I'll note, Mr. Rivera, we don't have a victim today, so I'm not going to release him on pretrial release. He's got no other history. I'll set the bond at $500. I am going to order that you have no contact with your, appears to be your father, Jose Sierra, that you maintain a separate residence from him. If he's living at the Woodbury Oaks Drive address, you'll have to live somewhere else. You can return there one time with law enforcement escorting you to get your personal belongings. Do not go back there alone. No contact with Jose Sierra. Possess no weapons, no firearms. Consume no alcohol or illegal drugs. Good luck.
Thank you, Your Honor.
May I say something?
I've appointed you an attorney. Understand that today is not the trial, and you also have the absolute right to remain silent. And the court has already set the conditions of release. It's probably in your best interest not to say anything at this point.
Thank you.
All right, good luck. Good morning, ma'am. Your name, please?
Marta Liliana Sanchez.
Marta Liliana Sanchez.
Ms. Sanchez, you're here for initial appearance, case 22MM1076. You've been arrested for a battery. It's domestic related. We also have a witness in the box.
Please raise your right hand. And nothing but the truth?
Yes.
You're allowed.
Yes. Yes.
Okay. All right. Good morning, sir. State your name, please.
Ryan Hill.
Mr. Hill, is Ms. Sanchez your wife?
Yes.
If she's released on bond or some other type of release, do you want to have contact with her, or do you want her to stay away from you?
No, no. I will, she gets contact.
I can't understand what you're saying.
She can have contact.
Are you in fear of her? You have to answer out loud, please.
No.
State, do you have any questions for Mr. Hill?
Are you okay with your wife being released without having to post a monetary bond?
Yes.
No further questions.
Does the defense have any questions?
No question, John.
Say there's no objection to PTR, Your Honor.
All right. All right. You qualify for pretrial release. I'll release you on pretrial release. That means you won't have to post a monetary bond with the condition that you have no hostile contact with your husband, Brian Hill, possess no weapons or firearms, consume no alcohol or illegal drugs. Thank you, sir. Good luck, ma'am. Good morning, sir. Your name, please?
Carlos Rosado Sifonte.
Sir, you're here for initial appearance in two matters. First is case 2022 CF 1921. You've been arrested for possession of cocaine. Bond is set at $1,000 in that matter. Second case you've been arrested for is on a warrant for a violation of probation. In that case, you were on probation for the offense of stalking. Allegations that you violated are that you committed the offense of possession of drug paraphernalia and that you are in arrears in payments. Judge set the bond at none for the violation of probation. I'll appoint the public defender in both cases. We have a third one?
Yes, it's two VOPs, Your Honor.
One's a warrant and one's a.
Oh, okay, it's the on-view arrest. So the on-view arrest, we've already got a warrant, so it's the same no bond on the on-view. Yeah, we'll keep it a no bond, and that'll be either resolved through a bond hearing or when you go to court to see the judge on the violation. All right, good luck, sir.
Thank you.
All right, Mr. Interpreter, I think that's all we have today.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you as well.
Good morning.
Good morning. Your name, please?
Shalonda Brand.
Ms. Brand, you're here for initial appearance on two matters. First, you've been arrested for a violation of probation. You were on probation for a felony battery. Allegations that you violated are that you failed to report back in October, that you tested positive for cannabis. All right, the judge set the bond on the violation of probation at no bond. The second matter you were arrested for was for failure to appear for a pretrial conference in December for possession of a controlled substance. That bond is set at $5,000. I'm going to appoint the Office of the Public Defender to represent you in both these matters. Okay, good luck.
Your Honor, Alicia Desiree, refused.
All right, so she's refused second day. I appointed the Office of the Public Defender yesterday to represent Miss Alessia.
We'll waive the appearance today, Your Honor.
Okay. The bond is going to be stayed at $250 on the petty theft. And wait, that's right, we got a second case. And additional conditions are no return to the Wawa 6500 West Sand Lake Road. No contact with the co-defendant. She's also arrested for possession of drug paraphernalia. That bond will be stayed at $500. Morning, sir. Your name, please?
Fernando Oliva.
Mr. Oliva, you're here for initial appearance. Been arrested for battery by strangulation and criminal mischief. Witness. And also arrested for resisting an officer without violence. Okay, I don't know if the witness is going to give any testimony today.
She don't want to give a testimony.
Okay,
She wants to leave.
okay. I do have a question. In your application for the appointment of the public defender, you indicated that you, the amount that you wrote down for income every 2 weeks, was that a gross amount or a net amount? Is that take-home pay?
Yes.
It's take-home pay? Based on that, you make too much to qualify for the public defender? Okay, on the battery by strangulation, state wish to be heard regarding bond.
Your Honor, we'd ask for a $1,500 bond. Battery, no contact, no return, separate residences, no weapons, no firearms, no drugs, no alcohol. And then on the resisting case, Your Honor, no objection to treating as subsidiary and a $100 bond.
All right, the court will grant a $1,500 bond. I am going to, this is on count one, the battery by strangulation. I'm going to order that you have absolutely no contact with Tiffany Thompson, maintain a separate residence from her. If she's residing at that Falcon Pine Circle apartment, you're going to have to live somewhere else. You can return there one time with law enforcement escorting you to get personal belongings. Do not go back there alone. Do not have any contact with her directly or indirectly. Possess no weapons or firearms, consume no alcohol or illegal drugs. Criminal mischief, set the bond at $100, and the resisting, the bond will be set at $100, or it'll be reduced to $100.
All right, the amount left to ask.
Okay, good luck, sir. Morning, sir. Your name, please?
Gino Perez, sir.
All right, sir, you're here for initial appearance on a couple of matters.
Yes, sir.
At this point, are you asking me to appoint the Office of the Public Defender to represent you in these cases?
Yes, sir.
Okay. All right, I'll appoint the Office of the Public Defender. You've been arrested pursuant to a warrant for robbery with a firearm and aggravated assault with a firearm, domestic related. I'm going to stay the bonds. Well, I guess on count one, I'll stay the bond at none. The aggravated assault with a firearm, does the state have a position on bond in that case?
We'll ask for a $5,000 bond, Your Honor, on count two.
Grant. $5,000 bond with the additional condition you have no contact with the victim, possess no weapons or firearms, no return to the scene. Next, you were arrested for a violation of probation. You were on probation for burglary, for dwelling, grand theft. Allegations that you violated are that you failed to report to probation back in October, changed your residence without permission, whereabouts unknown. That bond is set at none. All right, good luck, sir. Good morning, sir. Your name, please?
Jaime Castillo.
Mr. Castillo, you're here for initial appearance. You've been arrested for a battery. It's domestic related. Going to appoint the Office of the Public Defender to represent you, and we've got a witness to swear in the witness, please.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Morning, ma'am. Your name, please?
Salia Castañeda.
All right, ma'am. If if Mr. Castillo is released, do you want him to have contact with you, or do you want him to stay away from you?
Stay away from me, no contact.
Okay. All right. State, do you have any questions for the witness?
Yes, I understand that you want no contact. Do you have an opinion on whether or not he has to post a monetary bond, or he's released without posting a monetary bond?
He could be on a monetary bond. He has work, and I'm not gonna take that away from him, but I just
So
don't
can we-
want no contact.
I understand no contact, but can we release him without having to post a money into a pretrial release program? Are you okay with that?
Yes, that's fine.
Still including the no contact?
Yes.
No further questions,
And
Your
if he
Honor.
can get escorted with the police officer for his stuff at the house.
Okay. All right, does the defense have any questions for the witness?
No questions, Your Honor.
All right. All right, sir, I'm going to release you on pretrial release with the following conditions: that you have absolutely no contact with Celia Castaneda. You maintain a separate residence from her. You can return to the residence one time with law enforcement escorting you to get your personal belongings. Do not go back there alone. Do not have any contact, direct or indirect, with her. Possess no weapons or firearms. Consume no alcohol or illegal drugs.
May I approach the clerk, Your Honor?
Yes. All right, good morning, sir. Your name, please?
Roman Chavez.
Mr. Chavez, you're here for initial appearance. You've been arrested for a battery. It's domestic related. At this time, are you asking for the appointment of the public defender in this case, or are you going to, do we have an application for that? No. Are you asking for the appointment of the public defender, or are you going to hire an attorney?
No, attorney.
Okay. Do you want me to appoint an attorney?
It's my first time. I have no clue what I'm doing here, really.
Okay,
Your Honor, can I speak to him real quick as a friend of the court?
that's fine. And we can go ahead and swear in the witness also.
Raise your right hand, ma'am. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Good morning, ma'am. Your name, please?
Oh, yeah, good morning. Gabriela Chavez.
All right, Miss Chavez, are you the wife of Roman Chavez?
No, I'm his mom.
You're his mom?
Yes.
Okay. If he's released, are you in fear of him?
No,
Do you want him to have contact with you, or do you want him to stay away from you?
no, he lives with us.
Okay. Do you want him to come back and live at the house?
Yes.
All right, I see, I've read the affidavit. State, do you have any questions for the witness?
Yes, if something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
And are you okay with Mr. Chavez being released without having to post a monetary or money bond?
Yes.
No further questions.
All right, as a friend of the court, do you have any questions?
No questions, Your Honor.
I'm sorry, Your Honor, can I ask one?
Yes.
Is Mr. Chavez taking any medication?
No, he has not accepted any help. That's what I am looking for.
Okay, thank you.
All right, I'll release you on pretrial release, Mr. Chavez, with the following conditions: that you have no hostile contact with your mother or your father. It's Gabriela and Roman Chavez Sr. That you possess no weapons or firearms, that you consume no alcohol or illegal drugs, okay? And that you be subject to random urinalysis.
Your Honor, after speaking with Mr. Chavez as a friend of the court, would you be inclined to appoint the public defender?
Yes, I'll appoint the public defender. Okay, thank you, ma'am.
Thank you.
We can always remove us as counsel if he decides to file a private attorney. Thank you.
Morning, ma'am. Your name, please?
Sorry,
What's your name, please?
Alicia Mays.
Ms. Mays, you're here for initial appearance. You've been arrested for a battery. It's domestic related. I'm going to appoint the Office of the Public Defender to represent you. State, do you have a position on bond?
A $500 bond, Your Honor, all normal conditions.
Okay. All right, defense?
There's no criminal history. She does otherwise qualify for pretrial release, but as there's no victim present, it's in your discretion.
All right, I'm not gonna, I'll set the bond at $500 with the following conditions: that you have no contact with Brandon Sowell, that you maintain a separate residence from him. So if he's living at that Poppy Avenue address, you're gonna have to live somewhere else. You can return there one time with law enforcement to get your personal belongings. Do not go back there alone. Don't have contact with him, consume no alcohol or illegal drugs, and possess no weapons or firearms. All right, good luck, ma'am. Morning, your name, please?
Eric Pugh.
Mr. Pugh, you're here for initial appearance. You've been arrested for a battery. It's domestic related. All right, I'll appoint the Office of the Public Defender to represent you. State, you have a position on bond?
$500 bond, Your Honor, standard conditions.
Okay, defense?
It's reasonable bond conditions, Your Honor.
All right, I'll release you on a $500 bond with the following conditions: that you have no contact with Kareem Christopher Coote. Maintain a separate residence. If he's residing at that Wincliffe Circle address, you're going to have to live somewhere else. You can return there once with law enforcement to get personal belongings. You're not to go back there alone. You're not to have contact with him. Not to consume any alcohol or illegal drugs, and possess no weapons or firearms. Good luck.
Lawrence Rogers is medical.
Rogers is medical. Okay. All right, so medical we'll reset him for tomorrow. Or reset him within 24 hours of him being released from medical. Yeah.
We appointed in the interim.
Yes, I'll appoint the Office of Public Defender.
Thank you.
Morning, sir. Your name, please?
Morning, Donald Lagar.
Sir, you're here for initial appearance. You've been arrested on a Lake County warrant. Looks like aggravated stalking after an injunction, in violation of an injunction. The bond is set at none. They're going to notify Lake County that you're here. They'll come get you within 24 hours. It doesn't include the weekend, so maybe today, more likely it's going to be Monday before they come get you. And then they'll take you and see the judge there. Good luck, sir. Morning, sir. Your name, please?
Angel Ricardo Diaz.
Mr. Diaz, you're here for initial appearance. You've been arrested on an Osceola County warrant for a violation of probation on a 2014 case. The bond is set at none. They're going to notify Osceola County you're here. They'll come get you within 24 hours, not including the weekend.
Sure.
Okay, good luck.
Thank you.
Morning. Good morning, ma'am. Your name, please? All right. What's your name, please?
Fitzgerald Haley.
Mr. Haley, you're here for initial appearance. You've been arrested on a Seminole County warrant for a violation of probation. Bond is set at none. They're going to notify Seminole County that you're here. They'll come get you within 24 hours, not including the weekend. All right. Good luck, sir. Morning. Your name, please? What's your name, please?
Marcos Rosa.
Mr. Rosa, you're here for initial appearance. You were arrested on an Osceola County warrant for failing to appear for court. It looks like on a driver's license case. The judge set the bond at none. So they're going to notify Osceola County that you're here, and they'll come get you within 24 hours, not including the weekend. All right. Okay, good luck. Morning, sir. Your name, please?
I don't know it.
You don't know your name?
Nah, I don't know what's going on. What's going on?
Okay.
I hear voices.
All right. Is your name Jeremiah Richardson?
That's what they said it was, but I don't know what's going on.
Okay. Well, if your name is Jeremiah Richardson, you're here for initial appearance. You were arrested for a violation of probation, probation for aggravated battery. The allegations that you violated are that you failed to report to probation back in August, changed your residence without permission, whereabouts unknown, and you're in arrears on cost of supervision. The bond is set at none, and I'll appoint the Office of the Public Defender to represent you.
My bum was still up.
No bond. Good luck, sir.
This meeting is being recorded and or transcribed.
So, Ms. Edwards, if you want to just press mute so you don't get, or I'll press this bench conference to keep that from happening. All right, Madam Clerk, you can call the case, please.
In the interest of Lewis Frederick, case number 2020 CJ 187. Appearances starting with the state.
Alan Trobradovich.
And Amelia Edwards for Lewis Frederick.
Before we go further, Madam Clerk, should I be also have the regular record on also, or just rely upon the teams?
I have it recording on our end.
Okay, that should
on your little black box.
Oh.
But I do need Ms. Edwards to get her mic a little bit closer because she's very faint.
Amelia Edwards for Lewis Frederick. Is that better?
Were you able to hear that?
A little bit. I'll turn the transcript on.
All right, I turned the record on here also, so between the teams one and this one here, we should have it. All right, so yes, ma'am, whenever you're ready.
Your Honor, this will be a change of plea today. In case number 20 CJ 187, my client will withdraw his previously entered plea of not guilty and enter a plea of no contest as charged to count 4, lewd or lascivious conduct. In exchange for the plea, the state will be no processing counts 1, 2, and 3. The agreement is to order a predisposition report. We already have the predisposition report as well as the psychosexual evaluation, which is recommending probation.
Go ahead. Sorry, I was looking down at the computer. Whenever you're ready.
Yes, Your Honor. I also provided you a copy of the plea form, the disclosure notification of the possible future applicability of Jimmy Rice, as well as a copy of the proposed sex offender outpatient treatment plan, all of which have been signed by my client, and I have reviewed those with him.
Now we're obviously at the BRC, so he must be being held on adult charges. Do we know when he's going to be out of this facility?
We don't, Your Honor. He had a failure to appear on an adult case and his bond was revoked. The attorney on the adult case is, from my understanding, she is filing a bond motion. I don't know when that hearing is set. It would be in front of Judge Barber.
Thank you. Let me just pull up the predisposition report.
Your Honor, do you have a copy of the predisposition report? I'm not seeing it in Odyssey.
I have an extra copy if you'd like, Your Honor.
I don't see it on Odyssey, but sometimes I have it in my, just by email. I'm double checking that right now. 187, no, I don't have that if you want to bring that up here. All right. Do you want him to hand that to you, sir, or do you want him to bring it up?
There you go.
All right, thank you.
Your Honor, I have an electronic copy as well if you'd like it emailed.
This one.
Yes, Your Honor. I will forward it to Madam Clerk so we can have it e-filed.
If you can forward it to me so that way I can open it up right now as well.
Oh, it's the email you sent me.
Oh, fair enough. I'll look for it. Hold on.
Who is our clerk?
Miss Knight.
Miss Knight, okay.
All right, Mr. Frederick, do you swear that the information you're about to tell us here today is both true and correct?
Yes, Your Honor.
All right, I have an obligation to you to make sure you understand everything that's happening here today. So if at any point in time I say something that you don't understand, don't be afraid to ask me to repeat it or rephrase it. I don't want you to walk out of here thinking you didn't understand something or you wished you would have asked me to repeat or rephrase something. Fair enough?
Yes, Your Honor.
All right. Every person who's charged with a crime has an absolute right to say they're not guilty of the charge. And that presumption of innocence that attaches to any person charged with a crime, whether they're an adult or juvenile, that remains unless and until one of two things happens. Either the state proves the case beyond a reasonable doubt at trial, or the person enters a plea of no contest. So if you enter no contest plea, the first right you give up is that presumption of innocence. Does that make sense so far?
Yes, Your Honor.
Right. The next thing is, if you enter a plea of no contest, it means you're not contesting the charges. And if you're not contesting the charges, the next event that happens is a disposition. You might have heard it called a sentencing, but it's the same thing, the disposition of the case. So if you go from plea, no contest to disposition, it means there's not going to be a trial. Because the purpose of the trial is whether or not the state can prove the case or not. So the next set of rights that I'm going to go over with you are the rights that a person gives up because there's no trial. So therefore, without there being a trial, you won't see the state bring in witnesses or evidence against you. You won't get to see your lawyer challenge or cross-examine witnesses and evidence against you. You won't get to bring in witnesses to come to court to testify for you because, in my example, there's no trial. Because if you plead no contest, there's no trial. So you won't be bringing in witnesses to testify for you. And then, since there's no trial, there won't be a part of the trial where you testify or not. So just so you know, every person who's accused of a crime has the right to either testify or not at their trial. At the trial, if you choose not to testify, no one can hold it against you. Not testifying is no evidence of anything. If you testify, your testimony would be treated the same as any other witness. No one can force you to testify if you didn't want to testify. No one can stop you from testifying if you wanted to testify at the trial. It's always the accused's decision. But, like I said, if you plead no contest, there's no trial, and you give up everything that goes along with the trial. Does that make sense so far?
Yes, Your Honor.
Okay. So, like if someone said, well, why wasn't there a trial? The answer would be, because I pled no contest. Right? Sense?
Yes, Your Honor.
It'd be like, why didn't you bring in witnesses to testify for you at trial? Well, I pled no contest, so there was no trial. Make sense? Fair enough. Okay, so for the record, you're shaking your head yes. And sometimes you might hear me say that, and that's because we're being recorded here and the official record is what people say, as opposed to whether they're shaking their head. So sometimes you might see, like on TV or in court here today, where someone says, let the record reflect I'm approaching the witness with an item. That's because the microphones aren't picking up that someone's walking across the room to show an item. So that's why I had to say, let the record reflect, okay?
Yes, Your
I
Honor.
want to make sure you understand. All right, so I've been presented with a couple different items here today. The first item is something called disclosure and notification of possible future applicability of the Jimmy Rice civil commitment procedures. It appears to be signed by you and signed by Ms. Edwards, dated January 31st of 2022. So I take it you probably went over a couple weeks ago.
Yes, Your Honor.
Did you remember reading that?
Yes, Your Honor.
Did you understand everything on it?
Yes, Your Honor.
Do you have any questions about anything on it?
No, Your Honor.
All right, let me move on to the next document here. The next document is a waiver rights form titled Plea, where it indicates that you plan on pleading no contest to the charge of lewd or lascivious conduct, the third-degree felony. The state was going to drop the counts 1, 2, and 3, and it indicates your age is 18, your education is 12, and that and it lists rights that you give up by entering a plea. Did you read and understand this document?
Yes, Your Honor.
Do you have any questions about anything on this document?
No, Your Honor.
The next document I have is called a proposed plan for juvenile sex offender community-based treatment alternative and supervision by the Department of Juvenile Justice. It appears to have your signature. Oh, hold on. That's on that page. It has the prosecutor and your lawyer. On this page here, it appears to have your signature on it, the probation officer's signature on it, and then the next page, your attorney and the prosecutor's signature on it. On that, do you remember reading that document?
Yes, Your Honor.
Do you have any questions about anything on that document?
No, Your Honor.
So if you entered a plea of no contest, what would happen here today is I would accept the plea of no contest. The agreement then would be that you'd be on probation. And so today would, let me make sure, the probation would be what, to his 21st birthday?
Yes, Your Honor.
Correct.
Okay. Now, when people are put on probation up until their 21st birthday, there's times when probation can be terminated early. There's no guarantee that it'll happen, but get everything done, ask for early termination. And then what will happen is, first of all, probation will usually send in a request to the court after they send a copy to the state. The state attorney's office may say, we agree. They may say they disagree and they want to have a hearing. The victim has the right to be present and heard. So sometimes what happens is the state gets the request. They ask the victim about their impact. Sometimes the victim is okay with early termination. Sometimes they're not. And if they're okay with it, then with the early termination, then it can be done without a court hearing. A lot of times the victim wants to be heard, even if they're okay with it being terminated early, the victim still sometimes wants to be heard. So then we have a hearing, and it'll be just like today, although it'll probably be at the courthouse down and over on Juvenile. And then we would have a hearing, and then they'll hear from everyone. And then whatever judge is assigned to the case, whether it's me or another judge, because they rotate us judges every so often, would have the hearing to determine whether to terminate it early. I could tell you this, that if you violate probation, it's unlikely it gets terminated early. But when a person gets everything done without any violations, usually probation's really pushing to get the probation terminated, kind of as a reward to people that get everything done without a violation versus the people that ignore their requirements, and then those people typically either have a violation of probation filed against them, or probation isn't really in a hurry to try to help that person terminate early. So it's kind of an incentive to get everything done, because the purpose of sentences in juvenile cases is about rehabilitation as opposed to punishment. You're an adult now, but this was a juvenile case. So you'll see there's a very different thought process as to what should happen to juveniles versus adults. Because in your adult case, someone might be trying to punish you. But in juvenile, it's about rehabilitation with the hopes that there will never be another case after this one. So, and the reason why I'm saying that to you is because sometimes the people who are the listed victims of cases, including very serious cases, sometimes wonder why a person might get a lesser sentence than an adult who might be accused of the same crime. Because there are certain types of crimes that are sex-related where it's mandatory prison, that a judge would have to find a legal basis to go below mandatory prison. But in juvenile, there is no mandatory prison, but there are programs that exist. But judges can't even put people in programs unless the probation department is recommending a program. So I'm saying that to you, but I also understand that the victim might be listening also, and she may or may not have, or the victim may or may not have heard this before. All right. All right, so the charge here today is lewd or lascivious conduct. If you, has anyone made any promises or threats to get you to enter any type of plea here today, other than, and was it a withhold or an other than you'd receive a withhold adjudication, you'd be placed upon probation until your 21st birthday. You'll be required to comply with the proposed plan for juvenile sex offender community-based treatment alternative under supervision by the Department of Justice that we went over that you've read already.
Yes, Your Honor.
That you'd have to report to probation by, oh, I forgot to ask, does corrections, do you all have the ability to do fingerprints out here? Okay, good. So, but do you all have the ability to do DNA also, or just fingerprints?
Both, Your Honor.
Oh, perfect. Okay, so today in this courtroom, they'll do a set of your fingerprints. They'll take a sample of your DNA. Then you'll be on probation, as I indicated, by 4 p.m. the following business day from your release from this building, whenever that is. I'm sure from your perspective, hopefully really soon, but whenever that is, the following business day. So if you're released on a Friday, then by Monday, you have to report to the probation, for the juvenile probation. And then you'd be on probation, and you'd have the, comply with the proposed plan for juvenile sex offender community-based treatment alternative under supervision by the Department of Juvenile Justice. So Mr. Travatovich, other than what's on here, is there any other special or general conditions that you all have agreed with regard to this particular case?
And you're holding up this sex offender treatment plan?
Proposed plan for juvenile sex offender community-based treatment alternative and or supervision by the Department of Juvenile Justice.
Nothing additional as far as this sex offender treatment is concerned, but obviously there's all the stuff, the conditions on the PDR.
Okay.
Your Honor, would like to be heard as to the conditions in the PDR.
Okay, very good. We'll get to that in just a moment.
Yes, Your Honor.
Okay, and so then, Madam Clerk, what are the court costs?
$250.
$250, all right. So when there's mandatory court costs, there's nothing I can do about that, but people are allowed to do community service to pay it off. So every community service hour you do counts as $10 off what you owe. So you do 25 hours of community service, it'll reduce the $250 to zero. If you do 10 hours of community service, it'll reduce the $250, $100 to $150. And then whatever the math works out. It's any combination. Either way, the clerk will be looking for, I'm going to say $10 a month beginning July of 2022, but $10 a month means you can also do a community service hour. You can do that through probation. Okay, so let's talk about, you haven't entered your plea, you haven't been sentenced to anything yet. Let's talk about these other conditions that that are listed in the PDR.
Yes, Your Honor. Condition 1 is a 6 p.m. to 6 a.m. curfew. I would be asking for no curfew in this case, as my client is 18 years old. He'll be turning 19 on the 28th of this month. So I don't believe a curfew is necessary. I would also ask the court to consider reducing the amount of community service. The DJJ is recommending 100 hours. I have seen in similar cases where they've only been requiring 50, so I'm not really sure what in this case made them ask for 100 instead of 50. However, my client, when he is released, he will be working full-time at DHL. He also will be pursuing his GED, and he has a child of his own. So he has a lot of responsibilities in addition to completing the sex offender treatment, which will require multiple weekly sessions. I'd ask the court to consider a smaller amount of community service hours.
You say he's in the process of getting his GED, or he already has it?
No, Your Honor, he does not have his GED yet. He'll be working on a GED program once he's released.
Your Honor, I don't have an objection to the curfew. He does turn 19 next week. But the community service hours, I'll leave it in Your Honor's discretion, but obviously DJJ put 100 hours for a reason.
You get your GED, I'll reduce it 50 hours. So your GED will count as 50 hours of the 100, but it would be ordered 100, but GED counts as 50. Fair enough?
Yes, Your Honor.
It's part of this whole rehabilitation process. Everything that benefits you is good for you, and therefore education, GED, that will benefit you and greatly, as you'll find out later, because someday, I mean, working for DHL now, but someday you might want another job, and usually they say to people, Hey, did you go to college? No. Okay. Did you go to high school? Yes. Did you graduate? Yes. The GED is a graduation. So that puts you ahead of people who didn't have the drive and commitment towards getting the GED. Now there's millionaires and billionaires that have never graduated from high school, but those are exceptions. Most people have benefited because of getting a diploma and their high school diploma. In fact, in my office, I have my high school diploma displayed just like I do my other degrees, the law degree as well as my college degree. Smaller, for some reason, it's a much smaller diploma, but it's still very important. You can't get the other ones without first getting that one. All right, anything else with regard to the PDR?
No, Your Honor.
All right, so yes, I'll remove the curfew. Before, let's see, Mr. Travatovich, with regard to, I know you said the victim, I might give victim impact statement. Do you want me to do that after I accept the plea, but before I impose a sentence? Or when would you like me to have that accomplished?
I guess to get them out, because they've been on there for a while, I guess I would ask that we do it sooner rather than later.
All right, let's do it now. They should be able to hear you, so you can ask them.
Ms. Specht, are you on?
I'm sorry, what was that?
Hello?
I'm sorry, the last sentence you said it was.
Who are you asking for, Mr. Travatovich?
Well, so the mother's name is Kiara? Keyaya? K-E-Y-A.
Here, this is me. This is me.
Hi, ma'am.
All right, very good. Are you been able to watch on video everything and hear everything so far?
Yes, sir.
Okay. So any person who's the listed victim of a case has the opportunity to make a victim impact statement. And the victim impact statement typically is how this has impacted you. But it's not so strict that you can't say more than how it's impacted you. So this is your opportunity. If you'd like, no one can force you to say anything. But obviously, I'm here as a judge, the prosecutor's here, defense attorney, and the defendant is here, the juvenile defendant is here if you wish to make a comment. Or you can tell us that you don't feel comfortable. It's completely up to you.
No, I do wish to make a comment.
Whenever you're ready.
Because I hear a lot of them requesting like different leniency and thinking it's going to help him. I honestly don't feel so because it has been, he's still in trouble currently, and it impacted my daughter. It ruined her life. Like, it was to the point where she wanted to kill herself. Like, she made a suicide pact, and it took years and years of counseling, and it's still not done. And I don't think they realized that because when the situation came out, they basically tried to let so many different times threaten and discourage her from going forward and moving forward with it. And I don't think they actually realized that. I don't think he realizes what he took from her life. I don't think that's really understood, and I just feel like he just feels like it's a free ride. Like, you got to go on and do whatever you wanted all these years until now. But she hasn't had that same free, positive childhood that was taken from her.
Take your time, take as much time as you want, but you can continue when you're ready.
I just wanted you guys to know, like, if it was my choice, it wouldn't be probation, but me being a mother, I know I let it go ahead and, not go to trial, and I didn't fight with it because putting her back through that every time, it destroyed her life. I literally talked to the prosecutor, and the last time I talked to him, not the prosecutor, the prosecutor, he told me, like, basically, she broke down in his office, and that's why I let it go ahead and just plea out, because I can't keep seeing her destroyed about something. If I already took something from her, and it got drug out this long. It's just not something that just went away. That's all I want to say.
All right, well, thank you very much. Mr. Frederick, have you understood everything that I've said so far?
Yes, Your Honor.
To the charge that you committed the offense of lewd or lascivious conduct to that charge, do you plead not guilty and want a trial, or no contest and accept the plea agreement?
No contest and accept the plea, Your Honor.
And are you entering the no contest plea because you believe this is the best way to resolve the case for you?
Yes, Your Honor.
I'll find that you knowingly, freely, voluntarily, and intelligently have waived your constitutional rights with an understanding of the nature of the allegations and of the consequences of the plea. You've probably seen me a couple times looking down here on the screen here, the computer screen. It allows me to find that there's sufficient facts to accept the plea. I'll accept the no contest plea, and I'll give you the sentence that I told you you'd receive. And so that's what your sentence is. In a moment, the state will drop the charges, and now you have a chance to give like a little speech. I promise it won't be that long. But I heard you have a new kid, new child?
Yes, Your Honor.
Boy or girl?
A boy.
Okay. So I don't want you to comment about what I'm about to say. I just want you to think about something. Because someday, hopefully never, but maybe someday, someone might do something to your kid. And I'm sure you'll feel the pain that, like, we just heard the mom talk about the pain that she felt. And I just want you to think about that and how you would handle that as a parent, or if your kid ever was hurt by anyone, not necessarily this type of offense, but any offense. And I say that just because it's only fair on some levels. When you think about it from that perspective as a parent, you at least understand what the mom is feeling because she cares about her child. So I'm not asking you to comment that out. I just want you to, as a human being, think about what a parent would feel for their child who's helpless, okay? So just think about that. All right, State, are you announcing the null process on the other charges?
Yes, Your Honor. Pursuant to plea negotiations, the state will announce a null process counts 1, 2, and 3, and I will follow that up in writing.
Anything else, Ms. Edwards, other than me telling him his right and time to appeal?
I'd just like to make it clear, the predisposition report that you have, Your Honor, and that I forwarded to the clerk includes the proposed plan for sex offender treatment plan. The only addition that I made on that, with the approval of the state, I crossed out, or I wrote underneath the no unsupervised contact with any minor child under the age of 12. I hand wrote with the exception of unsupervised contact with any biological children. So I just want to make sure that that's clear, that that's something the state agreed to, and that that's going to be part of the order.
All right,
That is correct.
All right, thank you. So, and for the record, I've incorporated the PDR, imposed the sentence, including what's on the PDR other than what I've said wasn't going to be imposed, with the modification with the GED counting towards 50 of the 100 community service hours. All right, so you have, Madam Clerk, did you get everything?
Your Honor, I do have everything as to the PDR that Ms. Edwards sent to me. Thank you. As far as the attending school, that is for the youth to get GED, which will credit 50 hours of the 100 hours of community service.
Right, he's ordered to do 100 hours of community service. However, if he gets the GED, that'll count as 50 of the 100 hours, yes.
Thank you.
All right. So the last thing I have to tell you is the same thing I have to tell everyone. You have 30 days to appeal the judgment and sentence of the court. If you do so, you must do so in writing to the clerk of the court. If you can't afford an attorney, one will be appointed to represent you. In a moment, the corrections officers are going to take a set of your fingerprints, and they're going to do a DNA swab for you here. But other than that, that ends the matter for today, so I'm going to turn off the record. Thank you all. And
Your Honor, is there any way that the clerk can get us the case number for the fingerprint card?
The fingerprint card with the case number.
With the case number?
Yeah, we can give you the case number, yeah, that's it. All right, anything else? No? All right, so I'm going to go ahead and turn off. Mr. Travado, is your office going to contact the victim's family after this? I just want, yes, okay, so they're going to be contacting you shortly after court here, and I'm going to go ahead and terminate the proceeding here. Thank you all.
Judge, real quick, I apologize. Is the proposed plan for the juvenile sex offender, are you bringing that back, or is Ms. Edwards filing it with the court?
I'm going to bring that back, plus the order for blood or other biological specimens, the psychological evaluation and risk assessment, the plea form, the disclosure notification of possible future applicability of Jimmy Rice, and you already got the PDR, so that's everything. All right.
Okay, thank you.
Yep.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Thank you. We're getting the headphones on now. There we go.
There is contact, Your Honor.
Very good. Good afternoon, sir. Your name, please?
Roy Rogel Contreras Cabeza.
Roy Rogel Contreras Cabeza.
So you're here for initial appearance in 2022 MM 1088. You were arrested for solicitation of prostitution. I'll appoint the Office of the Public Defender to represent you. The bond is set at $500.
Okay.
Public defender. Fernando, you should have called us.
Ese número que no sé. No, para yo llamar. O el abogado. Ok.
Esa es la fianza. Va a salir por aquí. Esa es la fianza, señor. Por ahí.
Good afternoon, sir. Your name, please?
No oigo bien, yo no oigo bien.
I can barely hear.
All right. Is that better?
Sáquenmela para el lado acá porque este oído yo no lo oigo bien en este oído.
I cannot hear through this ear.
Are you able to hear me now?
Yes.
All right, sir, could you state your name, please?
Henry Moreno Ayuso.
Henry Moreno Ayuso.
You're here for initial appearance in case 2021 CF 6888. You were arrested for failure to appear at a pretrial conference December 14th of last year on a charge of possession of heroin. The bond is set at $10,000. Public defender is appointed. Okay. Good luck, sir.
Call and say this.
Good afternoon. Your name, please?
Hazel Vanessa Gonzalez.
Hazel Vanessa Gonzalez.
You're here for initial appearance, case 2022 CF 1924. You were arrested on a charge of, or charges of burglary of a dwelling, burglary of a conveyance, grand theft, second degree, battery and resisting an officer without violence. I'm going to appoint the Office of the Public Defender to represent you. Bonds have been set at $5,000 on count one, $150 each on counts 2 and 3, and $100 each on counts 4 and 5. In addition, I'm going to order you not to return to 10056 Brandon Circle. Order you to have no contact with the victim, Mr. Sanguine. Not to consume any alcohol or illegal drugs, not to possess any weapons or firearms. You're also out on bond for a trespass after warning. What's the state's position on the out on bond?
The bond should be revoked, Your Honor, and a new bond set double the original amount.
I'll agree to that. I'm gonna revoke that bond. I'll set a new bond at $500 on that case. Good luck.
Y de no tener, y en cuánto tengo que pagar la fianza.
And when do I have to pay the bond?
Did you say when? You pay the bond when if you'd like to get released before trial. There's no time limit. If I understood you correctly.
Okay. ¿Y cuánto sería el total completo?
And how much would the total be?
53, 55. The total will be $6,000. 500. Yeah, so it'd be 6,000 total would be the bond.
Your Honor, may I have a moment to confer with this next client as a friend of the court?
Yes.
Thank you.
All right, that's all our Spanish today. Thank you very much. Have a good weekend.
Thank you, Your Honor. You as well.
It says, supposed to be Malia? Rodas and Bullard and Law. Whoop, hold on. Yeah, that's Bullard too. Wait.
We're ready, Your Honor.
Okay. Just trying to find paperwork. Yeah, I don't.
Good? Okay, he's going to ask you some questions.
It's called user error. Okay. All right. I'm sorry, making you wait. All right. Good afternoon, ma'am. Your name, please?
Yes, Laura Lee Malia.
All right, Miss Malia, you're here for initial appearance. You've been arrested for trespass after warning,
Yes, yes I am.
and I'll appoint the Office of the Public Defender to represent you.
I mean, there's no need, Your Honor. I spoke with her as a friend of the court about the state's offer as well as went over the plea form. I believe she understands the process and what we're doing here today, and I'm confident she can enter a plea to resolve it today. Correct me if I'm wrong, Madam State, but I have a withhold and time served and no return to the Circle K.
Correct.
All right, Ms. Malia, I've been handed a plea form that it appears your signature is at the bottom indicating you wish to withdraw your plea of not guilty, enter a plea of no contest to the offense of trespass on property after warning that the agreed sentence would be a withhold of adjudication credit for the 2 days you've served in jail. You'd be ordered not to return to that Circle K, and I'll give you time to pay the cost. That'll resolve the case today.
Thank you, Your Honor.
Is that what you want to do?
Yes, I do, Your Honor.
Okay. I'm holding up the plea form. Is that your signature at the bottom?
Yes, it is.
Or to that charge of trespass after warning, how do you plead?
Not guilty. No contest.
I want to make sure you'd like to get it resolved today?
Yes, no contest.
Okay, I'll accept no contest. I'll withhold adjudication credit for the 2 days. I'll give you 350 days to get the cost paid. I'm going to order you not to return to that Circle K on 6250 West Colonial Drive. If you go back, they're going to recognize you. You're just going to end up back in jail. You don't want that.
Yes, you're right, Your Honor.
But you've got 30 days to appeal. Any appeal must be in writing. All right. Good luck, ma'am.
Thank you, Your Honor. Have a great day, okay?
Your Honor, would you consider making the court costs a lien, civil lien?
I'll reduce them to a civil judgment.
Thank you, Judge. Here, fine. Thank you, Judge.
Good afternoon, sir. Your name, please? What's your name, please? Mr. Brodus, you're here for initial appearance on 2 cases today. I'll appoint the Office of the Public Defender to represent you. First, you were arrested for failing to appear at a pretrial conference on a city ordinance case. It looks like it's possession and consumption prohibited, probably something akin to open container. Bond is set at $1,000 in that case. It's also a new arrest for trespass after warning, and bond is set at $500.
Did we make the offer to resolve both cases?
Okay. All right. And what was the offer to resolve them?
On the new law, the 2022 MM 1059, adjudication, credit for time served, no return.
Okay.
And then on the out-on bond, 21 MO 1337 on behalf of the city, it was adjudication, credit for time served, $10 filing fee, and the city's court costs.
Okay.
I have a moment to confer, Your Honor.
Sure.
Citizen? Your Honor, can we recall this case so we have a chance to review the plea form? I didn't have a chance to talk with Mr. Brodus in the back. He was in a different cell.
Sure, not a problem. Okay.
I appreciate that. Maybe just at the end of the pleable section?
Yeah, we'll call you back up. Just give you a chance to review the plea form if you'd like to resolve the case today.
Thank you, Judge.
Ricardo Cabello Sanchez bonded.
Good afternoon. Your name, please? Ms. Cunningham, you're here for initial appearance. You've been arrested for prostitution. I'm going to appoint the Office of the Public Defender. Your bond set at $500.
Your Honor, would you consider RORs? There's very thin criminal history, at least in here in Florida. It was a first violation charge. And she would hopefully qualify for the pretrial diversion program.
She would qualify for PTD.
The state believes she would?
Yes, Your Honor, she would qualify for our new prostitution PTD.
Okay, all right, because then I'll release her ROR.
Yes, ma'am.
Okay. All right. Good luck, ma'am.
Your Honor, may I approach?
Yes. Good afternoon, sir. Your name, please? Kenneth Davila. Mr. Davila, you're here for initial appearance, arrested for a trespass after warning. I've been handed a plea form indicating you wish to withdraw your plea, not guilty, enter a plea of no contest to that misdemeanor with the agreement that it would be a withhold of adjudication, credit for the 2 days that you served in jail, and you'd be ordered not to return to that Hyatt on Jeff Fuqua Boulevard. And you'd be ordered to pay costs, and I'll give you time to get the costs paid. Okay. Actually, you'd be not return to OIA, Orlando International Airport property. Okay. Is that your understanding?
Yes, sir.
Okay. Do you want to get it resolved? All right. How to that charge of trespass after warning? How do you plead?
No contest.
I'll accept that. I'll withhold adjudication, give you credit for 2 days, order you pay the costs, and I'll give you 350 days to get the costs paid. I'm going to order that you not return to Orlando International Airport property without a valid ticket for travel. Okay?
And I did have a chance to speak with him talk about the plea form as a friend of the court, Your Honor.
Thank you. All right, and you've got 30 days to appeal. Any appeal must be in writing. Good luck.
Hannah Fletcher bonded,
Fletcher bonded, thank you.
and Hashwa Johnson is medical.
Mr. Johnson's medical, so we'll reset. I'll stay the bonds at 500 each. We'll reset for an IA within 24 hours of his release from medical.
Your Honor, can you just set the bonds, because this type of medical, he'll be out for a while. It's like quarantine? Yeah.
Okay.
So you can just set the
But
bond.
even if he posted bond right now, he could be let out?
He could be let out.
Yeah,
if
so,
posted.
so I'll stay the bonds at 500,
Okay.
or we'll reset the initial appearance. It's of no consequence. It's either he can post the bond, or we'll reset him for IA if he hasn't bonded out when he's released.
Okay.
I just don't want to be somehow it's construed as a hold. I don't know if it would or wouldn't. Good afternoon, sir. Your name, please?
Good afternoon, sir. My name is Curtis Lawson.
Mr. Lawson, you're here for initial appearance. All right, you've been arrested pursuant to a warrant for the offense of battery. And the bond is set at $1,000. In order you have no contact with the victim. I'll appoint the Office of the Public Defender to represent you. Also possess no weapons or firearms. Yeah, and no return to the scene.
Yeah.
All right, good afternoon, sir. Your name, please?
Good afternoon. Kenny Moore.
Mr. Moore, you're here for initial appearance, been arrested pursuant to a warrant on a charge of petty theft of $100 or more. The bond set at $500. Be ordered not to return to target. I'll appoint the public defender to represent you.
Would the court consider a release on own recognizance in this case, Your Honor?
No, not based on his out-of-state history. I'll leave it at $500. No. No, it's going to be stated $500.
Your Honor, Jamie Piana, bonded.
Okay, what about Elian Padin Correa? inmate number 22003822.
He bonded.
He bonded, thank you. Okay. And Pania Castano, okay, bonded. That, they bonded, okay. It's a, last name's difficult. You better than me. All right. Good afternoon, ma'am. Your name, please?
Ariana Parrish.
Ms. Parrish, you're here for initial appearance. You've been arrested for prostitution.
Yes, sir.
Does it appear that she would qualify for the diversion possibly?
Yes, Your Honor.
All right, Ms. Parrish, what I'll do is I'll ROR you, release you without having to post bond based on that. It does not appear that she financially qualifies for the public defender at this point. Okay. All right, good luck, ma'am.
Your Honor, Francisco Pena, bonded.
Pena bonded, thank you.
Roberto Ramirez, bonded.
Your Honor, may I approach?
Yes. Thank you. Good afternoon. Sir, your name, please?
John Randall.
Mr. Randall, you're here for initial appearance. You've been arrested for trespass on property after warning. I've been handed a plea form indicating you wish to withdraw your plea, not guilty, and or a plea of no contest to that misdemeanor, with the understanding be a withhold of adjudication, credit for the 1 day that you served in jail, and you'll be ordered not to return to the liquor master on LB McLeod. That would, and you'd also have to pay the cost, so it'll give you time to get the cost paid. That'll resolve the case today. Is that your understanding? Is that what you want to do?
You resolve it today?
Yes.
Yeah, yes, sir.
Okay. All right, then to that charge of trespass after warning, how do you plead?
No contest.
No contest, I'll accept that. I'll withhold adjudication, give you credit for 1 day, order you not to return to the liquor master store at 3936 LB McLeod. Understand if you go back and they see you, you're just gonna end up back in jail. You don't want that, okay?
Yes, sir.
I'll give you 350 days to get the cost paid. You have 30 days to appeal. Any appeal must be in writing.
Thank you, sir.
Good luck.
Thank you, sir. Appreciate it.
Wilson Rodriguez, bonded.
Got a Lauren Thigpen?
She's behavior.
Behavior, okay. All right, I'm gonna appoint the Office of the Public Defender to represent Ms. Thigpen.
We'll waive the appearance, Your Honor.
All right, I'll stay the bond at $500, Public Defender's appointment. Bakiba Thomas? Mr. Thomas?
I have a moment to confer, Your Honor.
Yes.
Thank you, Your Honor.
All right, good afternoon, sir. Your name, please?
Yes, my name is Bakiba Thomas, sir.
Mr. Thomas, you're here for initial appearance. You've been arrested for trespass after warning. Got a $500 bond. I'll appoint the Office of the Public Defender.
Your Honor, there was an offer to resolve, and I spoke with Mr. Thomas about being able to pay a bond, and he told me he wouldn't be able to, and he didn't have any family that could come and help bond him out. We would request ROR and the guarantee from Mr. Thomas that he'll stay in touch with his attorney and show up for any future court dates.
He has prior failures to appear. With the history, I'm not going to ROR him.
Would you consider lowering the bond amount then, Your Honor?
What's the state's position on lower than the $500 bond?
No objection, Your Honor.
I'll reduce the bond to $150. Mr. Thomas?
He's talking to you.
Okay. I just want you to understand that this case, if the state decides to pursue the charge, the case is going to be mine. I've lowered the bond, okay? If you don't understand that if you don't show up to court, if the state files the charge and you don't show up, you risk the court revoking your bond and leaving it at none. Then you just sit in jail. Okay, so it's important that if you get charged, you have to show back up. All right, now I've appointed the public defender. I am going to order that you not return to the scene. That's Orlando Health, Randall Park, unless it's a legitimate medical emergency.
Your Honor, Mr. Thomas wishes to take the state's offer at this time after seeing the bond amount. If you're inclined to accept the offer or accept the plea.
The court will accept the plea. I'd like to get it resolved.
I'm sorry for the confusion, Your Honor.
That's fine.
The offer from the state, correct me if I'm wrong, Madam State, but was a withhold time served, no return to, I believe, I want to say Advent Hospital.
It's Orlando Health, Randall
Orlando
Park.
Health, I'm sorry.
On Dowden Road.
This is a no contest.
We're talking about all the rights.
All right, Mr. Thomas, I understand you want to withdraw at this point, withdraw your plea of not guilty or enter a plea of no contest to the offense of trespass after warning, with the sentence being a withhold of adjudication, credit for the 2 days you served in jail, order you not to return to the scene and the costs, and I'll give you time to get the costs paid. Okay.
Yes.
Is that what you want to do?
Withhold justification that's meaning it won't.
It means it's not a formal conviction. It'll show up on paper if law enforcement runs your record, or it'll be in the computer. Doesn't mean that it goes away. But if somebody asked you, were you convicted of this charge, trespass, you can say, no, I was not. It's not a conviction. Okay?
Yes, sir.
All right. So on to that charge of trespass after warning, how do you plead?
No contest.
I'll accept that. I'll withhold adjudication, give you credit for the 2 days you served in jail, order you to pay the cost. I'll give you 350 days to pay the cost. Order you not to return to Orlando Health, Randall Park unless it's a legitimate medical emergency. Okay?
Yes, sir.
All right. 30 days to appeal. Any appeal must be in writing. Good afternoon. Your name, ma'am?
Elizabeth Tutwiler.
Ms. Tutwiler, you're here for initial appearance. Been arrested pursuant to a warrant for the offense of stalking. I'll appoint the Office of the Public Defender to represent you. State, do you have a position on bond?
No, Your Honor, we'd ask for a reasonable bond, no contact with the victim, no weapons, firearms.
Defense, do you have a position on bond?
Just reasonable bond conditions, it does otherwise qualify for pretrial release.
We would object to a pretrial release.
All right, looks like she's got no history at all. I'll just note in the affidavit, it doesn't actually appear that there's any physical contact at all and no threats. Okay. All right, Ms. Tutwiler, over the state's objection, I'm going to release you on pretrial release with these conditions. You're to have absolutely no contact with Rebecca Franklin. You're not to go within 1,000 feet of 1220 Elmwood Street. You're not to possess any weapons or firearms. not to consume any alcohol or illegal drugs. When I say no contact with Ms. Franklin, that means no direct or indirect contact. Don't go by the house, okay? Yes. Okay. All right, good luck, ma'am. Good afternoon, sir. Your name, please?
Good afternoon, sir.
What's your name, please?
Harvey Lewis, brother. They got a bond today.
Okay. Did I hear you say Bryant?
This is Walter Lewis.
Okay. Walter Lewis, okay. All right, sir, you're here for initial appearance. You've been arrested for 2 counts of battery. I'm gonna appoint the Office of the Public Defender to represent you. Bonds are set at $500 on count 1, $100 on count 2. I'm gonna order that you have no contact with either of the victims. Order you not to return to the scene of the arrest. Possess no weapons or firearms.
After this next client, Your Honor, may we recall Mr. Brodus?
Yes.
Thank you.
Gary Kuntz, his behavior.
Behavior. Mr. Kuntz, I'm going to, I'll appoint the Office of the Public Defender.
We'll waive the appearance, Your Honor.
Okay, I'll stay the bond at $500. Public Defender's appointed.
Brodus, please.
Good afternoon, sir. Your name, please?
Joshua Briggs.
What happened to Rashad Morris? He was RO, okay. All right, Mr. Briggs, you're here for initial appearance. Been arrested for a DUI and for a refusal. At this time, are you asking the court to appoint the Office of the Public Defender to represent you, or are you going to hire an attorney?
Yes. My wife was supposed to call to get me an attorney.
Okay.
I haven't made contact with her since then.
Okay. All right, so at this point, the bonds are set at $500 on count 1, $100 on count 2. It looks like this is... Yeah. All right, in addition to the bond, I'm going to require that you consume no alcohol or illegal drugs while out on bond. All right, good luck.
Sir.
Yeah. Yes. Okay, we'll recall Cornelius Brodus.
Yes, Judge. Mr. Brodus has had a chance to review the plea form, and I spoke with him briefly as he returned about the terms of the state's offer. I believe on both the trespass and the failure to appear was an adjudication of guilt, credit time served, and no return to the scene of the incident. The failure to appear is case number 2021 MO 1337AO, and the new trespass charge is 2022 MM 1059AO. I'm going to mark the case numbers on the plea form for inform.
All right, Mr. Brodus, that he handed a plea form. It looks like you signed indicating you wish to withdraw your plea of not guilty in both these cases. Enter pleas of, looks to be an open container, city ordinance violation, and a second case, trespass after warning, misdemeanor, that you'd be adjudicated guilty in both cases. You'd have to, you get the credit for the time you served, which is 2 days on each case,
Your Honor, he has 4 days on the MO case.
4 days on the city case, 4 days on the open container, and 2 days on the trespass, with the additional condition that you not return to the scene of the trespass and the costs, and I'll give you time to get the cost paid. Is that your understanding? Do you want to get the cases resolved today?
Yes.
Okay, all right. All right, in 21 MO 1337, that's the open container, the city case, how do you plead to that?
You can say no contest.
No contest.
I'll accept no contest. And in the other misdemeanor is 22 MM 1059, that's trespass after warning, how do you plead to that?
No contest.
Okay, I'll accept no contest, please. Going to adjudicate you guilty on the city case, 4 days credit. Order costs, I'll give you 350 days to get the cost paid. In the misdemeanor case, trespass, I'm going to adjudicate you guilty, give you credit for 2 days. Order you to pay the cost, and I'll give you 350 days to get the cost paid. Those are to run concurrent to each other. Okay. So you'll be. Okay.
All right. Hold on. Can't hear you.
Just the Fitzgerald application. Okay. And counsel, I need you to sign the plea form.
Yes, Judge. May I approach?
Yes. Okay, you're good. You have 30 days to appeal, sir. Good luck.
Rivera,
Yes.
bonded.
Bonded, thank you.
Michael Myers, bonded.
Michael Myers, bonded. All right, good afternoon, sir. Your name, please?
Albert Passmore.
Mr. Passmore, you're here for initial appearance. You've been arrested pursuant to a capias for failing to appear for a violation of probation hearing back in November of 2012. The judge set the bond at none. I'm going to appoint the Office of the Public Defender to represent you in this case. Okay. Yeah, we'll just reappoint the public defender. Oh, on the last gentleman, it looks like the public defender previously represented him. Do you want to go ahead and just get dates on the violation of probation?
You want to bring him back? Sure. As to the violation, we'll enter a denial, Your Honor.
Okay, all right. So we're doing that to give you court dates now. It'll speed up the process.
Division 84, BOP status, March 14th at 8:30 a.m. in 4B.
Call us, we might be able to get you in there sooner. That's one set for now, okay? That's okay.
Giovanni Santana, bonded.
Bonded, thank you.
Marcus Bonilla, bonded.
Bonilla, bonded, thank you. All right, good afternoon, sir. Your name, please?
Tyrone Burley.
Mr. Burley, you're here for initial appearance. A couple cases today. First, you've been arrested for grand theft, motor vehicle, 22 CF 1928. That bond set at $1,000. Okay. Second, in 2022 MM 1082, you're arrested for resisting an officer without violence. I'm going to consider that subsidiary. I'll reduce that bond to $100. Last, you were arrested in 22 CT 968 for driving with suspended license. Consider that subsidiary. I'll reduce that bond to $100. Order that you not drive without a valid license. I'll appoint the public defender in all three cases. Good afternoon, sir. Your name, please?
Sean Michael Davis.
Mr. Davis, you're here for initial appearance. Been arrested for possession of MDMA. Bond set at $1,000. I'll appoint the Office of the Public Defender to represent you.
Your Honor,
Yes, sir.
would you consider lowering the bond as it was less than a gram of MDMA? If you would consider either $250 or $500 bond?
Let's see. No, he's got a fairly significant prior history, including failures to appear, including last year. So I'll leave the bond at $1,000. I'll appoint, yes.
Thank you for your consideration.
Good afternoon, sir. Your name, please?
Yasser Edmond.
Mr. Edmond, you're here for initial appearance. You were arrested pursuant to a capias for failing to appear for a status hearing July of last year on charges of attempted burglary of an occupied structure, petty theft, loitering or prowling, and attempted burglary of a conveyance. Judge set the bond at none. Do you have the PD briefs? And the public defender was previously appointed. Good afternoon, sir. Your name, please?
Juwan Faley.
Mr. Faley, you're here for initial appearance. You've been arrested pursuant to a warrant for carjacking with a firearm and aggravated assault with a firearm. Those bonds are going to be stayed at none. I'll appoint the public defender to represent you.
For the record, Your Honor, is it because count one is a punishable by life offense?
Yes.
He is entitled to a full evidentiary hearing with his attorney downtown as well, for the record.
Yes, he is. Okay.
Thank you.
Good afternoon, sir. Your name, please?
Robert Harris.
Mr. Harris, you're here for initial appearance. You've been arrested for robbery with a deadly weapon. I'm going to appoint the Office of the Public Defender. Okay. State what's your position on bond.
I believe it's a PBL.
I don't believe so, Your Honor. I checked the statute this morning. I think with a deadly weapon, it drops it down to an F3. Excuse me.
He is entitled to bond, Your Honor. We would ask, however, even though it is not a punishable by life felony, that the serious nature of the crime be taken into consideration.
Your Honor, can I say something?
No.
For the record?
Hey, don't say.
No.
Steve, hold on. If you have a question, you need to address it to the attorney first, and then he'll let you say if you can say it out loud. Almost there. 2A. Robbery. I believe this is, I believe this is going to be a second-degree felony. Robbery, I'm sorry. Robbery with a, it's a first-degree felony, the standard bond would be $5,000. I'll set the bond at $5,000. I'm going to order you have absolutely no contact with the victim. Order you to possess no weapons or firearms, consume no alcohol or illegal drugs.
Yes, sir.
Good afternoon. Your name, please?
Yusuf Hedrington.
Sir, you're here for initial appearance. You've been arrested for failing to appear for arraignment January 27th of this year on charges of possession of a firearm by a convicted felon and carrying concealed firearm. And the judge set the bonds at none. I'll appoint the public defender to represent you. Good afternoon, sir. Your name, please?
Gregory Herndon.
Mr. Herndon, you're here for initial appearance. Been arrested for attempted burglary of a conveyance. Bond set at $1,000. I'll appoint the public defender to represent you. In addition, I'm going to order that you not return to the scene where you were arrested in this case. All right. Good luck.
Percy Joseph refused.
Refused. Okay. All right, I'm going to appoint the public defender to represent Mr. Joseph.
We'll waive the appearance, Your Honor.
Okay, so he was arrested for, on a warrant for, looks like grand theft, motor vehicle. I'll stay the bond at $3,000. And let's look at the date on that. 9th of February. Yep, and he was out on bond from January for another theft. I'll revoke that bond and set it at none. Okay, let's look at it. And he's also got another case, another grand theft motor vehicle. That's got to separate here. It looks like four cases, one out on bond. So this, I'll stay the bond at $3,000. 2022 CF 1925 grand theft motor vehicle, I'll stay that bond at $1,000. I'm going to revoke the bond, set it at none, and 22 CF 1450. And then he was also arrested for driving with suspended license, and that bond will be stayed at $500. Appointed in all cases. Good afternoon. Your name, sir?
Yotis Kendo.
Mr. Kendo, you're here for initial appearance. Been arrested for possession of cocaine with intent to sell or deliver with a weapon, unlawful use of a two-way communication device, and possession of a firearm or ammunition by a convicted felon. All right, State, do you have a position on bond on count one?
No, Your Honor.
Okay. Defense?
Just reasonable bond conditions, Your Honor.
I'll set the bond at $2,500 on count one. $1,000 on count two will be stayed. $2,500 on count three. It'll be stayed. All right. Good afternoon, sir. Your name, please?
Jose Marrero.
Mr. Marrero, you're here for initial appearance. I got several. cases. First case, you were arrested for leaving the scene of a crash, property damage, and driving with suspended license. Looks like third or subsequent offense. Bond on count 1 is stayed at 500. Count 2, bond is stayed at 2,500. Second case, you were arrested for failing to stop or remain at a crash involving injury. And driving with it looks like driving with, it says without a license causing death or serious injury. Yeah, with serious bodily injury. Okay. And those bonds are set at $2,500 on count 1 and $5,000 on count 2. And the public defender's appointed both cases. All right, good luck. Good afternoon, sir. Your name, please?
Richard McHugh, Your Honor.
So you're here for initial appearance. Been arrested for possession of MDMA. I'm going to appoint the public defender to represent you. Your bond set at $1,000.
Okay.
All right, good luck. Good afternoon. Your name, please?
Cora Purdue.
Ms. Purdue, you're here for initial appearance. You've been arrested for shooting or throwing a missile into a dwelling, structure, or vehicle, and criminal mischief. Bond set at $5,000 on count 1, $100 on count 2. Appoint the public defender.
Your Honor, would you consider lowering the bond amount on count 1? She's been unemployed for the last 12 months and has very limited criminal history, especially in Florida.
What's the state's position on that?
I have no objection to a $2,500 bond. It's count 1, Your Honor.
All right, I'll reduce the bond on count 1 to $2,500. I'm going to order you not to return to 218 Cottage Hill Road. Possess no weapons or firearms. Okay, good luck, ma'am.
Thank you.
Tip.
Robertson bonded.
Roberson bonded, thank you. All right, good afternoon, sir. Your name, please? Mr. Shell, you're here for initial appearance. You've been arrested for driving with a permanently revoked license. I'm going to appoint the Office of the Public Defender to represent you. The bond is set at $5,000. All right, good luck.
Your Honor, would you consider a lower bond on this count as well? I don't believe. I rescind my argument, Your Honor. I didn't see a traffic in the history, but I do now. I would still request, if in your consideration, a lower bond amount.
It is no objection.
You said state has no objection?
Correct, Your Honor.
All right, I'll reduce the bond to $2,500. The order, do not drive while out on bond. Good afternoon, sir. Your name, please?
Jonathan Shivers.
Mr. Shivers, you're here for initial appearance. You've been arrested for burglary of a structure and grand theft of a motor vehicle. Okay. Bond is set at $3,500 on count 1, $150 on count 2. I'm going to order you not to return to the scene. It's 8125 East Colonial Drive. Order you to have no contact with victims, witnesses, or co-defendants in this case. Good luck. Good afternoon, sir. Your name, please?
Bobby Lamar and Marquis Sims, sir. Good afternoon.
Good afternoon, Mr. Sims. You're here for two cases. First, you've been arrested pursuant to a warrant for charges of possession of a firearm by convicted felon and unlawful discharge of a firearm. Those bonds on the warrant have been set at $7,500 on count one, $1,000 on count two, with the conditions that you have no contact with any victim or witnesses, don't possess any weapons or firearms. Second case, you were arrested for possession of MDMA, and that bond is set at $1,000. Yeah, didn't I say that? Oh, I said no contact, no return to the scene, or no return to victim's home. That's what, yeah. All right, so $1,000 on the second case. I'll appoint the public defender in all cases. Yes, sir.
Your Honor, may we request a bond reduction on the warrant, count one? Perhaps it wouldn't be exact. Well, I guess it could be I guess it would be $3,750.
The possession of firearm by convicted felon. Let's see, 70. I'll reduce the bond to $4,000.
Thank you, sir.
That's on the schedule.
Thank you, Judge.
Good afternoon, sir. Your name, please?
Joshua D. Terrell.
Mr. Terrell, you're here for initial appearance. You've been arrested for pursuant to a warrant. Charges battery, evidencing prejudice.
We have a witness.
The bond on the warrant is set at $10,000.
Your Honor, we have a witness as well.
Okay, all right, let's swear.
She's not a witness, Your Honor. She's to inform the court that he is homeless. Mr. Terrell is homeless, and he's living in a homeless shelter. They provided documentation of that information. I think it's a factor when considering bond conditions or amount.
All right. Does either side wish to inquire of the witness?
State does not, Your Honor.
Would the state's comments or the witness's testimony change anything about the homelessness issue in your bond determination, Judge?
Are you asking me?
I'm asking the court if they would like to hear testimony or if the state's explanation was sufficient in your consideration.
I'll ask a question. Ma'am, are you here today just simply to testify he's living in a shelter, he's currently homeless?
That and that he is my main provider, and I have severe medical issues, and I have documentation that he takes care of me.
Okay.
I'm diabetic, I have diabetic seizures, and I have a lot of heart issues. And that we have actually been at Daily Bread for almost a month. Well, a little over a month, so we are now considered Florida residents by the law.
All right, at this time, the court is going to stay the bond on the warrant at $10,000. I'll appoint the public defender to represent you. The condition, it's a $10,000 bond, no contact with the victim, no weapons or firearms. Good afternoon, sir. Your name, please? Mr. Townsend, you're here for initial appearance. I'm going to appoint the Office of the Public Defender. You've been arrested pursuant to a warrant, charges of burglary, conveyance, and grand theft. Bond on count 1 is set at $2,500. Count 2 will be reduced subsidiary to $500. Good luck. We have a Wilson Rodriguez.
He had bonded.
He had bonded. Thank you.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.